You fell. Maybe it was in a Baltimore grocery store, maybe it was on a poorly maintained sidewalk in Baltimore County, or a dark stairwell in an apartment complex in Montgomery County, or a hotel with a ceiling that collapsed. You're hurt, and now you're wondering if you even have a case. And more than that, you're worried that because you fell, somehow maybe the whole thing was your fault. Let me walk you through how this actually works under Maryland law. I'm attorney Bobby Zirkin. I've been a personal injury attorney for over 25 years and a member of the Maryland House of Delegates and the Maryland State Senate. Slip and fall cases here in Maryland are some of the most aggressively defended premises liability claims that I see. And the reason is simple. The property owner, the business, and their insurance company all have strong incentives to put this on you. Maryland's legal rules make that strategy particularly effective. Here is the thing you must understand about Maryland slip and fall cases. This state uses what's called contributory negligence. That means if a jury finds that you were even a little responsible for your own fall, you recover nothing, not reduced damages, nothing at all. Insurance defense attorneys know this. They will look for any evidence that you were distracted, that you saw the hazard and walked through it anyway, or that you were somehow moving carelessly. Even a tiny percentage of assigned fault can end your entire case. So let me tell you what you need to do and what you need to avoid. First, evidence. If you fell in a store or on a commercial property, photographs of the hazard matter enormously. The size of the spill, whether there was a wet floor sign or any warning at all, the condition of the surface, footprints or cart tracks through the liquid that show how long it had been there. All of that helps to tell the story about what's called notice. And notice is the key legal element in these cases. We have to show that the property owner knew about the dangerous condition, or that it existed long enough that they should have known about it and addressed it. Second, the incident report. Fill it out if the business requires, but choose every word very carefully. Describe specifically what happened. You slipped on a wet surface with no warning sign. Do not say, I should have been watching where I was going. Do not write, I might have been moving too fast. Do not minimize your injuries by saying you think you're fine. You do not know yet whether you're fine. Third, get medical attention that same day. A gap between your fall and your first doctor visit will be used against you. Fourth, call an attorney before you talk to the property owner's insurance company or anybody representing the property owner. Here's what these cases can produce when they are handled correctly. We recovered $375,000 for a client injured at a hotel where the ceiling had collapsed and a piece of the ceiling had hit him in a shower. We recovered $120,000 for a patron injured outside of a restaurant. We recovered $105,000 for a client who fell on a defective sidewalk in Baltimore City. The property owner knew about these hazards. They did not fix them, and we proved it. I had a client, a woman in her 60s, who fell in a grocery store because of liquid on the floor with no warning sign anywhere. She blamed herself. We showed the court the store's own inspection records, which revealed they had not done a floor walkthrough in well over an hour. That was notice. That's a case. If you were hurt in a slip and fall here in Maryland, call Zirkin Schmerling Injury Attorneys at 410-753-4611. Free consultation. No fee unless we win. Don't go at this thing alone.